We'll start off with House Bill 897. Representative Collins, I know we have been working on this for a while. Is Judge Tripp Self here, by the way? Judge Self? No? Okay. He'll be here when he can. I know he had court yesterday, but I want to make sure we recognized him. We took a look at this in the past. It went to rules. It's been recommitted over some concerns. I know that there's been a lot of back and forth between interested parties on this, making sure we get this right. It ought not be lost on anyone that this is where we are in terms of the state of the law. As I understand it, the state of the law right now, as per a Supreme Court decision last year, is that sex between a student and a teacher is okay as long as it's consensual. That's where we are right now. And what we're trying to do right now is to fix the law, which really amounted to a technical defect that the Supreme Court rested upon in making its decision last year. What we're trying to do is to remedy that defect in the law in order to get back to where we thought we were in terms of making a statement with regard to sexual contact between teachers and students. Is that a fair summary of where we are?
I think, Mr. Chairman, that is a fair summary all the way around with that.
If you would, let's, in the interest of time and the other bills we've got on the agenda, let's focus on, if we could, the changes that have been made as a result of the recommittal.
Yeah. No problem, Mr. Chairman.
Okay,
I appreciate it.
Okay.
I'll redirect you to page 3, line 69. As the many conversations that were had here concerning the possible outside consequences of a like a community issue or a coach or something like that, the language has been changed to a teacher, principal, assistant principal, or other administrator of any school, and that takes away the agent language that was previously in here. That was a concern. It came from rules. It came from many others that I had. So this captures the vast majority, 95+% of what this bill needs to do. If we find out there's something else, then someone else can feel free to bring that back next year. We need to capture the essence of the bill, and that's exactly what this does. The other thing is adding line 81, that section right there. Simply, after we looked at it a little bit further and going back to the original law, this just clarifies the ones in so that there's statutory language for the correctional facilities and just that they were underneath this as well from the standpoint. And that's all. That's the only changes that have come back to the committee. And that was after addressing some concerns from rules. Mr. Chairman,
do we have any? I mean, we don't want to have a situation where we go through these changes and we end up weakening from where we began with when the court made its decision in the Chase case.
No.
Is that a possibility, or have we strengthened, or are we back to status quo? But what we've changed, we've remedied the defect.
I believe we have. And one of the things, and let me just state this: one of the issues that we had was, again, there was one line in the old legislation or the old code that basically hinged the whole Chase decision. We've had an attempt to make it read easier and make it lay out. That was where make sure we had everything covered, and that's what we've done. It does not, especially in regard to what most people feel this, and what I originally brought this for is dealing with teachers or administrators and having sex. It covers that. That is now where we want it to be. The other issues that were caught up, I think, just got caught up in a good legal, I'll just say a legislative vetting process that we all go through. I think this captures the essence. It does what we need it to do, and would ask your favorable consideration.
Questions from members of the committee? I assume members of the committee have had an opportunity to take a look at the new draft, LC 294176S. Any questions from the membership to the author? Mr. Setzler.
Thank you, Mr. Chairman. To the author, appreciate your work. Have you kept track of your hours on this bill?
If from my other life, billable hours will be off the chart at this point. But no, it's been a labor that has been good. So
just for clarity, and we've all been part of this conversation, the agency still exists in the other law enforcement context.
Yes.
It's just the agency piece. We're not condoning it. We're just silent to it in this bill. In
the educational system, yes, and that was the concern that most had. So we took it out.
And the prosecution community, Mr. Moss, has taken a look at this and is feeling good about it. Okay. Ms. Abrams.
At the appropriate time, I'd like to be recognized for a motion.
This would be that time.
I move to passive. Let's see which time it is. HB 897 LC 294176S.
Ms. Abrams makes the motion to do pass HB 897 by substitute LC 294176S, seconded by Mr. Levitas. Are there any amendments? No amendments. Any further discussion? Seeing none, on the general lady's motion, all in favor say aye.
Aye.
Opposed? The ayes have it, and the motion is adopted. Thank you, Mr. Collins, for your hard work.
Thank you for the committee.
Be happy to help in rules if necessary. My sense is there may be a comfort level there at this point.
Yeah, I have been working with them as well, and I think there will be on this.
Okay.
Good piece of legislation.
My second-hand understanding is that we're about to take an extended break, so if during that interim there needs to be some help on that, just to make sure we've got clarity for all involved, that's not a problem. Happy to do it. This is a must-do. Let me call House Bill 1155, Representative Loudermilk, if you want to come forward and sit in one of the chairs up front. I think, Mr. Setzler, you wanted to go ahead and present as well. Y'all work. Okay, good. That's fine. As a co-sponsor. All right. Just for procedural purposes for members of the committee, it's a pretty uniform process here in terms of when a bill comes out of subcommittee. What I've learned in this position is it's half this job is administrative in terms of getting things scheduled at the proper time and getting them potentially out the door or not out the door, as the case may be. But what we'll do is hear from the subcommittee chair, Representative Ramsey. That came out of your subcommittee yesterday, is that correct? Or no? All right, what we'll do, members of the committee, is, as we have with all bills that come out of subcommittee, assuming we have a subcommittee chair at the meeting for the full committee, is get a report, and then we'll go ahead and hear from the author. And what that'll do, I think, is if there are any issues that came up in subcommittee yesterday that you want to point to, that we could go ahead and hear from the authors as part of their presentation as well. And I'll leave that to you.
And I may have to punt to Representative Setzler to deliver that report. I had to call on him to chair the vast majority of the subcommittee hearing. I was presenting a bill. I will say there were no changes to the bill. I think the debate was largely philosophical. There weren't any technical issues that were raised. If Representative Setzler can tell me if I'm wrong if something was brought up.
That's fine. Representative Setzler and Representative Loudermilk, what I'd ask you to do, if that's the case, is to go ahead and make your presentation as briefly as humanly possible. And as you're doing that, Mr. Setzler, if you could go ahead and interject with any points that were made as part of the subcommittee meeting, I think that would give the members who are not part of the subcommittee, including myself, a macro view of the issue as it came down yesterday. So I'll open the floor for y'all.
You might want to speak to the issue of the script. Mr. Chairman, we are going to have some slides to show during the presentation. So if the camera person could just take that into advisement, you're in a prime piece of real estate. So.
Okay. And I know Mr. Lafayette is here, who has perhaps the only person in the room who knows how to get that screen down. So would this be the time to go ahead and employ that? Or?
I think we can get that moving while Representative Loudermilk is presenting.
All right. Rob, are you okay with that? Okay. Let me ask you this. How long is that presentation going to be? Because I have another bill after this, and we need to be out of here by around noon.
We've got a person that's going to be presenting with us 15 minutes, 10, 15 minutes.
Okay. All right, Rob, let me ask you to go ahead and get that screen, and then if I knew it that easy. Okay, thank you. I've been educated. All right, Representative Loudermilk.
Thank you, Mr. Chairman, and we'll try to breeze through this as briefly as possible. But it is a very important issue, and I want to thank the subcommittee yesterday for what I thought was a very good, thorough hearing. And as was stated, it really boils down to a philosophical issue in the stance of belief. 1155 comes about something that I didn't realize had happened and happened in the past, but is the documented instances in our history of overt acts of eugenics, or the proponents of using birth control and abortion to limit or eliminate a certain population from this country based on their race. We've seen other nations and more recently states adopting the ability to do sex selection when it comes to abortion. What 1155 does is it simply applies the same standards that we use in employment and housing and education of discrimination standards, that you cannot choose whether to hire or fire someone based on their race or their sex or their color. In fact, we pull the language right out of the 1964 Civil Rights Act that you can't use those standards in housing, education, and employment. We're simply applying those to abortion. That you cannot solicit or coerce someone to have an abortion with the intent to eliminate or abort the child based on the sex of the child. That you cannot use abortion as a way of eugenics to specifically have an abortion because of the race of the child, to eliminate that child, their ability to receive life based on their sex, their color, or their race. And that's the impetus of the bill. Is that I can go through separate sections, but most everybody in here are very learned attorneys, and I'm sure you've had an opportunity to read it. But that's the focus of it. There's Section 1 outlines that the solicitation or the coercion would be illegal, basically trying to convince someone to have an abortion because of the sex of the child, or solicit someone to have an abortion because of the sex of the child or the race of the child. Section 3 also would make it a crime that an abortion is committed under those same circumstances. We've also put a right of standing for the mother and the child in the civil code to give the mother the ability, which she doesn't have right now, if an illegal abortion is performed, and we're just using code that already exists that defines illegal abortion, code that we've already had in Georgia. If any criminal abortion is performed, then the female or the pregnant mother would have a right of standing to seek damages and seek action in civil court. In a nutshell, Mr. Chairman, that is what this bill does. Representative Setzler has a lot of knowledge into this. We also have several people willing to testify in that these actions have occurred in the past in this country and that they do occur as well currently. And so if the chairman so pleases, we're able to answer questions, or we do have a presenter as soon as Representative Setzler can get our slides ready.
Representative Setzler, did you want to do your slides and then open up for questions? I think that might be more.
Yes, Mr. Chairman, I think we would.
Might be procedurally a little better.
We've got a Ms. Catherine Davis. She's the Director of Minority Outreach for the Georgia Right to Life. She's going to walk us through this. She really has the expertise in this area. In fact, I'm going to trade places and let her sit where I am.
Let me ask, before you do that, if that's the case, before that, and that comes under the category of witness testimony, does any member have any questions for the authors? You want to hold? All right. Okay, if that's the case, we'll go ahead and defer. How do you want to do that presentation?
Good morning. My name is Catherine Davis, and I'm the Director of Minority Outreach for Georgia Right to Life. In 2007, the Georgia Senate issued a resolution that basically said eugenics legislation targeted the most vulnerable upon us, including the poor and racial minorities, wrongly dehumanizing them under the color of law for the claimed purposes of public health and good. And they resolved that they would support the full education of Georgia's citizens about the eugenics movement in order to foster a respect for the fundamental dignity of human life. The eugenics movement began actually in the 1800s in the mind of Sir Francis Galton. He is considered the father of eugenics. He is the cousin of Charles Darwin. Charles Darwin, as many of us know, is the author of a book called The Origin of the Species by the Means of Natural Selection, or The Preservation of Favored Races in the Struggle for Life. Sir Francis Galton and Charles Darwin combined their knowledge together to father and author the eugenics movement. Charles Darwin said, at some future period, not very distant as measured by centuries, the civilized races of man will almost certainly exterminate and replace the savage races throughout the world. The break between man and his nearest allies will then be wider, for it will intervene between man in a more civilized state and some ape as low as a baboon, instead of as now between the Negro or Australian and the gorilla. Sir Francis Galton said, average Negroes possess too little intellect, self-reliance, and self-control to make it possible for them to sustain the burden of any respectable form of civilization without a large measure of external guidance and support. Dr. Benjamin Hayes, a eugenicist in 1905, carried out that theme as America began to embrace the eugenics movement. And he said, the black man has never been a competitor, but has always been subservient to the white race. And just so long as he remains subservient, his position is secure. And just as so soon as he becomes a competitor, his fate is sealed. At around that same time, we began to see movement in the birth control movement in America, beginning with Margaret Sanger. Margaret Sanger is the founder of Planned Parenthood, and she fully embraced the eugenics movement that was being funded by the Carnegies and Rockefellers and Ford. They needed a skilled activist to get things done, and these are Margaret Sanger's words, not mine. And she began the American Birth Control League in 1926. As you will see, it says on its negative side, it shows us that we are paying for and even submitted to the dictates of an ever-increasing, unceasingly spawning class of human beings who never should have been born at all. These were her sentiments and the sentiments of the American Birth Control League. Too many Negroes are born yearly, advocates of birth control says. This is what she was publishing in her birth control review. She was also on the speaker circuit with the KKK, and she had a dozen invitations to speak to similar groups, and she actually bragged about that in her biography. In 1942, she said, even this will not be sufficient because I believe that now, immediately, there should be national sterilization for certain dysgenic types of our population who are being encouraged to breed and would die out were the government not feeding them. Intervening in this period, Margaret Sanger launched her Negro Project, which she launched in 1939. She basically said to Dr. C.J. Gamble in that launching of that program that they were going to hire black ministers to teach and preach birth control from the pulpit. And she said to him, the minister is the man to straighten it out should it ever occur to any of their more rebellious members that we want to exterminate them. In 1944, Gunnar Myrdal published a book called The American Dilemma, The Negro Problem in Modern Society. It was published by Harper and Brothers, a very prominent publisher, and the president of Harper and Brothers, Cass Canfield, was also the president of Planned Parenthood when this book was published. And in that book, he said, Gunnar Myrdal said, all white Americans agree if the Negro is to be eliminated, he must be eliminated slowly so as not to hurt any living individual Negro. He went further and said birth control facilities could be extended relatively more to Negroes than to whites, since Negroes are more concentrated in the lower income and education classes. President Nixon embraced that philosophy. And in the 1960s, his own chief of staff, Ehrlichman, I think that he was the chief of staff, but one of his staffers said that Nixon considered blacks as inferiors. And I have
Let me interject just for a minute here.
Yes.
I really need us, with all due respect, to focus on the bill.
I
really need us to focus on the bill.
Yes, sir.
And while I respect historical context, this is 2010, and what I'm interested in, why we get paid the really big money here, is words on paper. If you have some information to share regarding current times, what may or may not be happening here, I don't know, that would be helpful to the committee as it relates to the bill that we have here. So I would, again, very respectfully encourage you to shift focus to the bill and anything that you'd want to go ahead and bring up with regard to how whatever may be happening now or may not has relationship to it that supports, I assume supports, the underlying intent of the bill. I hope you can be patient with me on that.
I certainly can be patient with you on that.
Oh,
so
thank you.
Let me fast forward
Thank you so much.
to today. It is our contention that the locations of Planned Parenthood clinics has been specifically designed to carry out the initiative of what President Nixon launched in the 1960s, which was to control the birth rates of blacks in this nation. And he launched the Population Control Commission that was chaired by John D. Rockefeller, and that organization promoted and encouraged the funding of organizations like Planned Parenthood to address what they considered to be the Negro problem and controlling the birth rates. Supreme Court Justice Ruth Bader Ginsburg just last year indicated that it was her understanding that that the Roe decision was decided because there was concern about population growth, and particularly growth in populations that we don't want too many of. What we have seen is that the clinics then have been strategically located by design in minority neighborhoods. And that is what this slide shows. This is Oregon, where Oregon is only 6% black, has a 6% black population, but they opened a clinic just a week or two ago in the very section of Oregon where the black community, where 45% of the blacks are.
May I interject and ask you, do you have some sort of empirical information like that or something else on related to Georgia?
The Georgia clinics, we have 11 clinics that are open in Georgia today. The lion's share of those clinics are located in the urban areas where blacks reside. For example, there's a clinic in Ashford Dunwoody. We all know that Ashford Dunwoody is not majority black, but the location of that clinic is in the section of Ashford Dunwoody where blacks reside. In all 11 clinics, the statistics show that the lion's share of the people going into those clinics, the least amount was 47%. The highest amount was 94% of the people entering the 11 clinics in Georgia were black. In 2008, the most recent statistics that we have issued by the state of Georgia, there were 32,066 abortions performed on Georgia women, not women outside of Georgia. And of that number, 18,901 were performed on black women in the 11 clinics in Georgia.
Do you have that information on paper that can be shared with members of the committee at some point?
I certainly do.
Because I think that's something that committee members would want to take a look at.
I certainly do, sir. So what we are saying here is that given the history, and also, I'm sorry, there's one more issue on the sex selection question. I lost my slide here. Where'd it go? This is based on 1990 and 2000 census data in the United States of America. Sex selection abortion is illegal in most nations of the world, and in the United States there are 3 states that have already banned it: Illinois, Pennsylvania, and Oklahoma. We find that this study shows that sex selection is most prevalent in some Asian cultures, and there is substantial evidence from the 2000 census that shows that prenatal sex selection has increased in a 10-year span from 1990 until 2000. What the statistics show us is that the first child, if the first child was a girl, we had a pretty even distribution of almost 1-to-1. If the second child was a girl, you saw a slight increase of disparity in regards to the boy-girl. But then when you got to the third child, it leaps exponentially. So if you look at those little pink and blue people, what it shows is that one of those girl babies would not make it because of the increase in sex selection. And this is a study that was done not by a pro-life organization, but it was an independent study that was done without political affiliation.
What organization did that study?
Columbia University. Thank you. Thank you. So we believe that eugenics is indeed being carried out. It's alive and well in Georgia and in the United States today. We believe the data supports it out. The Georgia statistics, we are leading the nation according to the CDC data that was published in 2005-2006 in the number of abortions performed on black women. Of the 38 states that report to the CDC, Georgia was leading the nation in the number of abortions performed on black women. And we believe that that is by design.
Thank you.
You're welcome.
Yes, sir.
Mr. Chairman, we just appreciate your indulgence giving us the...
We will. Ms. Davis, let me ask you to keep your seat if you could. Mr. Loudermilk, if you have any further, and then we'll open up for questions on the witness.
Yeah, thank you, Mr. Chairman. We appreciate the opportunity. We just wanted really to, because we understand in the legal process as legislators that we just don't arbitrarily enact laws because it may be a good idea, but it would be like outlawing alien abductions. It would be a good idea, but it's something that doesn't happen. We just wanted to establish that eugenics has happened in this country. It's been overt. That there has been cases, documented cases, of abortions because of limiting a specific race. So we wanted to establish that this has happened in our country. And whenever it has happened, there's the potential of it happening again. We also have witnesses that are willing to come forward at the chairman's pleasure to testify that this type of coercion and solicitation is happening while on a limited basis. Some believe it may be a larger basis, but is happening today. And really the context of the bill is it boils down to, do you believe that it is wrong to have an abortion simply to eliminate the child based on its sex or race? And that's the purpose of the presentation, is just to really give the information to the committee that this has happened in the past and has the potential of happening, and in some cases happening now.
I can appreciate that. I just have to be respectful of time. But we do appreciate the information. What I noticed, Illinois, Pennsylvania, and Oklahoma, that jumped out at me a little bit as an interesting cross-section of this country, frankly, both geographically and politically. Has there been any, and if the answer is yes, I'd invite the sponsors and interested parties to supply committee members with the documentation to go along with the previous request. In Illinois, Pennsylvania, and Oklahoma, either prior to their adoption of a measure such as this or subsequent, was there any empirical data that proved out, that demonstrated that this, in fact, had been happening prior or had happened subsequent to the law being passed, and there were some enforcements of the law? If you know that. If you don't, that's fine. I just would ask that question if that exists, if it could be supplied to the committee in a timely basis.
Again, Mr. Chairman, I wanted to I think the research basis for that work is what you see here, and that's why we provided this slide. Again, it's a Columbia University study, peer reviewed by Cal Berkeley, and and it's, I want to say, as a co-sponsor of Representative Loudermilk on this bill, we're providing data. We're not. It's impossible to draw conclusions from those numbers that definitively this action happened, that there was a sex selection abortion, or that this or that the other happened. I think the data, however, if you recognize going back all recorded history, the boy-girl breakdown has been 50.001% plus or minus for all of human history. And if you've got a skewing of literally 6 to 7 at the second child and 3 to 2 at a third child, specifically in cultures that have this expressed in a very significant ways overseas in their native countries, when in 1990 there was no skewing at all in the census numbers prior to this, the early sex identification being available scientifically, in 1990. And again, in 1990, this first child, second child, third child numbers would be 1-to-1. But with the introduction of the ability to screen for sex in the 5 to 6 in another procedure 10-week range, you see this dramatic demographic impact happening.
You're talking about the current screenings that can occur right now during pregnancy.
Correct. That with the introduction of that in the 1990s, in a way that can be shown in the 2000 census, you see this dramatic impact demographically, and it's happening only in the cultures that express this overseas. You look at this, and one's left to ask the question: if these countries have passed laws to prohibit this, and we're seeing dramatic demographic impacts like this, and a large sample this study provides, one's left to ask the question: is this not a concern for this legislature? That's all that definitively is being proposed, but the numbers are what the numbers are in a peer-reviewed academic context. So I think these are being put before the committee as raw data to evaluate thoughtfully.
Ms. Abrams.
Thank you. I have a few questions first for the witness. With the information that you provided regarding the clinics, do you have statistical data that correlates the cost of the services provided at these clinics versus the cost of services at private inpatient clinics? Because do you have that information that correlates that data?
I do not.
Do you have information that correlates the accessibility of these clinics based on the access to public transit versus those clinics that would be situated, or private providers that would be situated in areas where there is no public transit?
I do not.
Do you have any information that correlates the zoning for these clinics and locations based on the populations in these areas?
I do not.
Do you have any information regarding the percentage of the population of women in Georgia who've had abortions as compared to the African American population, that comparative data?
Yes, I do. That is the data I just referenced.
You referenced the number of African American women, but how does
Georgia.
that? Right. Do you correlate that to the number of overall abortions performed in Georgia?
Yes.
And can you compare that? Can you provide what that ratio is?
Certainly. The total number of abortions performed in Georgia in 2008 was 36,094. Mm-hmm. Of that number, 20,993 were performed on black women.
Now, are those all the abortions performed, or all the abortions performed by clinics that have to report to the CDC?
All that were performed by clinics that have to report to the state of Georgia.
So those would not include any private providers that aren't subject to that reporting requirement?
That's correct.
Thank you. And to Mr. Loudermilk, my question is, actually it's to Mr. Setzler. You referenced the gender selection. Typically, the cultures that perform gender selection, it's self-selected. The parents decide that they would opt for a child of a certain gender, correct?
I don't consider myself an expert in those cultures. I'll follow your line of questioning.
I guess my question is, this addresses criminal solicitation, but traditionally sex selection is determined by the parents, particularly in those cultures that prefer one gender over another. It's culturally based. So my question is, how does criminal solicitation address the fact that it's typically the mother who's making the decision? It seems to me that given the data that you've shown, criminal solicitation doesn't really attach the issue. What we should be doing is outlawing sex selection abortion, if that's the goal that you have for that portion of the bill. Can you speak to why we're only attacking the provider and not attacking the parent? Because you specifically carve out an exception for a parent deciding to abort based on sex, but you do not do so for the provider?
Thank you for the question, and it's a relevant question. There are a number of the relatively simply drawn bill addresses conditions that affect coercion, that affect solicitation, and then affect the physician themselves. If we believe there's a practice, for example, sex selection abortion, if it's the policy directive or the policy position of this legislature in the state of Georgia that it shouldn't be legal, that based on sex people can make abortion decisions, then should it be legal for a doctor with knowledge that someone's seeking an abortion based on sex? Is it reasonable that a licensed physician should be party to that with knowledge that the person's seeking it on a criminalized basis? I mean, if a physician knows that the purpose that this abortion's being selected and being sought is sex selection, should the doctor not have a duty to say, wait a minute, this is being sought for sex selection purposes, that's illegal, I can't be party to this. That's all this seeks to address.
Can you show me where your bill does that? Because your bill only addresses solicitation and coercion. If the mother comes in of her own volition and the doctor performs the abortion with knowledge, that is not covered under either solicitation or coercion. So how does your bill actually, where's the nexus between that intent and this bill?
This is I'm not sure, this is the version you're looking at. If you look in section 3 of the bill, if I could take the copy from the member. I've got one right here. Look in section 3, lines 46 through 48. It says, and again reading above, a person commits the offense of criminal abortion when that person performs an abortion, and then you go down to line 46, with the knowledge that the pregnant woman is seeking an abortion based in any way on account of race, sex, or color of the unborn child, or race. So it's if the physician has knowledge that it's being sought for purposes of race, sex, or color, then the physician could perform that abortion legally. So they would be party to an otherwise criminal act.
Okay, so then to follow that line, if a woman goes into a clinic, a public clinic that's on a MARTA line because it's the only one she can get to, and she says, I need to have an abortion because I'm a poor black woman and I cannot afford to have this child. If that abortion is performed under the terms of this bill, that mother would be exempt from criminal solicitation, but that abortion doctor, because he has knowledge at the time that he performs that abortion, will have committed the offense because he understands that the mother believes that on account of the race of that child, and because would a court be able to extrapolate and indeed bring a charge against that doctor because the doctor knows that the woman doesn't want to bring another poor, let me change my scenario, doesn't want to bring another poor black boy into this country, into this world? Would that doctor then be subject to this provision?
No. What this provision does is if the woman came in to seek an abortion because she didn't want to bring a child into the world, the current state of the law in Georgia and the state of constitutional law nationally allows the woman to seek that abortion. If she comes in under the scheme that's proposed in this bill, if she comes in and says, I'm pregnant and I'm aborting this child because I don't want to have a biracial baby, or I'm aborting this child because my parents will kick me out of the house if I bring a biracial baby home, and they're prejudiced and they're forcing me to do this, and the doctor has knowledge that it's being sought with a race-based animus, the doctor says, well, I can't do this. I can't perform this abortion because you're seeking it based on race. You're using an otherwise legal procedure to do something that should be illegal, which is eliminating a person based on race.
But under on line 46, if you read lines 46, 47, and 48, it says that with the knowledge that the pregnant woman is seeking an abortion based in any way on account of the race. So if the woman says, I do not want to have this baby because I do not want to bring another poor black child into this world, that doctor would be immediately criminally liable if he performs that abortion. Is that not true?
If the designation of race was the motivation, if she makes a statement, a hearsay statement, if she makes a statement that says, referring to herself, referring to a black child as in a slang term, that's that's certainly not going to be caught in this.
Why, can you explain to me why it would not be caught in this? Because the language says based in any way on account of the race. And I would, and I apologize for cutting off, but I do want to narrow this. You just used the hearsay language. Any proof of this would likely come from a hearsay statement. It would be the statement of the mother versus the statement of the doctor. If the statement of the doctor, if the mother says, "I said this," can you show me why that scenario would not be captured under this language?
Right. If, with knowledge the pregnant woman is seeking the abortion based on account of. Okay?
Yes.
If the doctor makes the determination that a black woman is seeking the abortion so that another black child's not coming into this world, and it's purposely intended that a black child doesn't come into this world, then yes, the doctor would not perform the abortion.
So
if there's a race-based animus to the action, then it's illegal.
I guess my concern is I don't see animus listed in here. This language says based in any way on account of the race. It does not indicate that animus is necessary as an element of the crime. Would you be amenable to amending this language to indicate that there has to be some higher level than simply a notion of race as a predicate for the decision?
No, what we're seeking to do here is we're seeking to recognize, and again, this is part of what we go back to the Civil Rights Act of 1964 on. And when you set the bar that you've got to say that it's solely based on this, that it's only for this reason, you almost have an absurdity in the law. It's a nullity almost. What we're seeking to do is if the doctor knows that there's a racial-based component to the action, then just like in employment law, if there's an employer that says, you know what, you're not really doing a good job for me, and this is a right-to-work state, I could normally fire you, but I thought about it, and you're not doing a great job, but because you're a black person, and I don't want a black person to work in my shop, I've made the decision you're fired. That's against the law. There's really there are two reasons you can't fire somebody in a right-to-work state. You can fire someone because they're wearing a blue necktie. You can fire a person because you don't like the jokes they tell. You can fire a person for just about any reason. You can't fire them because they're black, and you can't fire them or white or Latino or any color based on race, and you can't fire them based on sex. Because what we recognized years ago is that someone's doing something that would otherwise be legal, but they're using it to accomplish something which isn't legal, which is discrimination.
And Mr. Chairman, if I don't want to belabor this, but you raised an additional point. The distinction between the Civil Rights Act of 1964 and what you're proposing is that those were all laws designed to prevent discrimination, meaning eliminating access. You are, by the very nature of this bill, eliminating access because given you mentioned a nullity, this is actually so expansive as to capture anyone who makes any statement that could be seen to capture race or color or gender. And if you let me finish, the concern that I have is that the language of this is so expansive as to be the exact opposite of what was intended by the Civil Rights Act. The Civil Rights Act is designed to protect access and to deny any person from denying access to a service or to employment. What you were doing what this bill would essentially do is create a chilling effect for any doctor because of the hearsay. I mean, by your own admission, hearsay would be allowed to be an element of this, and you would have an abortion that could be sought if the patient seeking the abortion makes a comment that in any way evokes race, color, or sex. The doctor, by then performing this abortion, has violated your law because there is no standard in here requiring animus or an intent to discriminate. It simply requires that based in any way on account of race, color, or sex. And if I'm incorrect, if you can show me in the law where that is laid out, I'd appreciate it.
I will. And let me get back to some. I think you made some assertions of what I represented. You talked about hearsay, and you talked about the animus piece. I want to get back to what this seeks to address. This is a criminal statute. Mm-hmm. The notion that a statement by somebody, a offhand remark, represents a clear criminal intent is just on its face not true. That doesn't apply anywhere else in our law. One could make the contention that a statement could be made that could lead to a conviction, but we recognize in a criminal context, when you're taking this before a jury that has to bring a unanimous decision beyond any reasonable doubt, that the purpose that this was being sought was for race or sex, an offhand remark's not going to bring a conviction. Now, you can certainly make the contention at your level as a legislator, oh my gosh, but we're throwing it wide open, this is loose language. What we're simply seeking to do, though, is we're simply seeking to draw this and thread the needle in narrowness and have the narrowness and the breadth to which, of the circumstances to which this address be just right. And I can tell you when you sit down with a team of a number of attorneys on this, attorneys that have litigated at the federal level, attorneys that have litigated in other states, and you craft this to accomplish exactly what we're trying to accomplish, which is if the doctor knows that part of the decision is based on race, he can't perform it. If to my point before, I think you would agree, any law we're trying to pass, if you've got to prove that it's based solely, that if any other evidence can be suggested, there's any other reason that's motivating the person would make it not apply, that becomes an absurdity. So as we draw this down, I think I would ask the committee to look, which acknowledge that the pregnant woman is seeking the abortion based in any way on account of, there's this causality, that based in any way on account of, not made a statement to the effect of, but based in any way on account of, and that language was picked very carefully to your point, that you've got to show that causality between the, not words that were spoken, not an offhand remark, but that there is an intent, a criminal intent, or there's an intent that this abortion be performed on account of race. And if the doctor makes that professional, recognizes that within their professional judgment, then they're subject to this. And I think this is consistent with other parts of the law and how we would draw this. And I don't think we want to. I don't think I'm trying to construe more or any less than that in it.
Mr. Chairman, if I may ask one final question, and then I will relinquish. Mr. Setzler,
after.
Mr. Setzler, what you just said is that a statement wouldn't be proof. Intent tends to require a predicate act. There has to be some. Typically, when abortions are performed, when a woman goes into a clinic, it is a conversation typically between the woman, the doctor, and the nurse. There tend not to be other persons present. There tend not to be any records taken other than the medical history of the woman. Exactly how would you prove criminality? Because criminal intent in almost any other criminal solicitation act, there's a predicate act. If you say that hearsay cannot be used as proof, what proof would be required? Would the doctor have to write down in the chart, I'm performing this abortion? So if you can walk me through the scenario, taking to your point, the very practical application of this law and the fairly expansive language of any account, how would the account be made? How would the doctor have professional knowledge except through a statement made by the pregnant woman? If you can walk me through what that would look like.
And I would respond to your question with another question, parenthetically. There's been a lot of testimony in this committee of the inviolate nature of the doctor-patient relationship. That in the counseling process and the process of doctors understanding what's in the best well-being of the patient, understanding the intentions for things, that the doctor enters into this conversation with the patient to really understand the intentions and the purposes. I think to suggest that an offhand remark is going to have a greater impact on the understanding of the doctor that is having this conversation with the patient, and that is really seeking to understand the purposes in performing this medical act. I think might be distracting. I didn't make a remark with respect to hearsay evidence. I think the point is in this, it's not our job as legislators to create every circumstance in which one could prove or disprove something. I think what we're seeking to address here is recognizing that doctors in the state are licensed professionals. They typically operate in good faith in accordance with the law. And if a doctor knows that a person is seeking an abortion based on race, then that doctor, acting in good faith and according to the laws of the state, would have a duty to say, I can't perform this because you're seeking it for a race-based reason. That's what this seeks to do. I don't think it's the job of this committee to contemplate all the sets of potential facts in which someone could prove this. I think we're simply expecting doctors to act in good faith and consistently with this to make sure doctors can't be agents of an otherwise illegal act.
Ms. Benfield.
Thank you, and I apologize for being late. I had a meeting with constituents, and so if you've covered this already, my apologies. But I do have concerns about doctor-patient confidentiality. Did you all discuss that already? Has that already been covered? And this is just a dovetail on the discussion you've already had. So what I'm hearing from you is the duty of the doctor to report a suspected race-based or gender-based abortion would trump the duty that the doctor already has with doctor-patient confidentiality, because doctors have an obligation to protect their patients. So how do you deal with those conflicts?
That's one of the reasons we have the hold harmless clause.
What clause?
There's a hold harmless clause in here.
Where is that?
We're not looking at it anyway. If you look on section 3, lines 51 through 53.
That's for the woman. I'm talking about the doctor. The doctor has a confidentiality to his or her patient.
Correct. The point of lines 51 through 53 is that we're not getting the doctor and the patient in this competitive situation where they're going to be ratting on each other and that kind of thing. We're not trying to create a circumstance where the patient or the doctor has a duty to report the patient. That's one of the reasons we've got this hold harmless clause. What we're simply seeking to do in this is doctors acting in good faith, consistent with the law, see it very clearly they can't be party to the elimination of a person based on sex or race using the otherwise legal abortion procedure to do that. And this gives very clear guidance to the physician that you can't be, in recognizing someone else is seeking an abortion based on these purposes that we believe are wrongful purposes. Doctors can't be party to that. If they have knowledge of this, they have to say, listen, I'm a licensed physician. I'm operating in good faith. I can't let this go forward because I'd be breaking the law to do that. And it's against the law to perform an abortion based on those purposes.
Okay, if I could just do a follow-up. Okay, so what I'm hearing you saying is you're not creating a duty or an obligation upon the doctor to report suspected abuses of this were to become law, and that these lines 51 to 53 would hold him harmless or her harmless. I still don't see where you're getting around the confidentiality. I mean, if the doctor in good faith thinks this is happening and proactively reports it, how do they get around? They've got a duty. They do have a duty to their patient, a duty of confidentiality.
Yeah, and we certainly recognize that. This bill doesn't seek to change the confidentiality standards in any way, and I don't think it does, in effect. It's, again, the doctor has no duty here to report this. The doctor simply has a duty not to perform it if he recognizes in the professional judgment that it's being sought based on account of race or sex. The doctor has a duty not to perform the abortion, but they have no duty here to report to anyone that somebody was seeking one.
Okay,
that's
so
not the intent of the bill.
What you're saying is if the doctor does not want to violate his or her duty of confidentiality to their patient, what they should do is just not report this, but they shouldn't perform the abortion.
It's the doctor's duty to say, I can't perform the abortion. I recognize you're seeking this for race or sex. I can't do that. It'd be illegal for me to do that, so I'm sorry, I can't perform it, if that's your reason.
But for them to report it to the authorities would be violating their duty of confidentiality to their patient.
I would see that as a breach of confidentiality, absolutely.
Okay. Can I ask one more?
Let me just take one question, and I'll yield back to you. Is there
thank you.
hypothetically any problem in having a reaffirming sentence referring to that confidentiality within that provision? Just to make sure it's completely clear.
We've tried to make a pretty clear statement of hold harmless. I mean, certainly
well, it's a hold harmless in terms of.
But I mean, if it be the will of the committee, and that's an important piece to state clearly the confidentiality piece.
Just something to think about.
Sure.
Ms. Benfield.
Yeah, just to continue along that line, let's reverse the scenario. It's not the doctor who's reporting, but it's the patient who reports that they indicated that they were having the abortion because they didn't want to have another girl. And the doctor's brought into court and has to defend him or herself. How does the doctor defend him or herself without violating the duty of confidentiality that they have to their patient? I mean, I just think the confidentiality issue is huge.
Well, if I may, Mr. Chairman, in a situation where a patient may go to their doctor and make a request that the doctor give them an illegal prescription drug, which they do not need, I mean, is there a requirement that the doctor report that, or just the doctor stands back and says, I can't do that? I mean, I see this as a similar act where if a patient asks a doctor to do anything that's illegal, I don't believe there's a reporting requirement for that doctor to report. If he just says, I'm abstaining, I'm not going to do this because it's an illegal act.
I mean, I hear what you're saying, but this also gives a provision where the doctor reports potentially, and that's breaching confidentiality. If they're dragged into court, then they've got the confidentiality issue.
There's nothing in here about reporting.
The only reporting we have is if there is a criminal investigation, then the reports of the investigation are turned over to the medical board. By the prosecutors. No requirement for doctor to report.
How does that information get to the authorities if there is a potential criminal charge? If not, in most cases, it would be from the doctor or from the patient. And in those situations, which I think would be the majority of the situations, you are dealing with confidentiality issues.
Yeah, all this says is if there's a criminal investigation that's initiated pursuant to this code section, that at the conclusion of said investigation, that the prosecution makes available to the state medical board the evidence that's collected during that investigation, so the state medical board can perform their duty of administrative action. That's the only reporting piece in this, is that the prosecution makes available to the state medical board, if the state medical board needs that, information collected by the state for the state to use in an administrative proceeding. Again, it recognizes that the state medical board doesn't have the investigative powers that the prosecution does, and wants to ensure that there's the ability that due attention be able to be performed by the state medical board.
Does the state medical board have the authority to subpoena confidential medical records?
They do, in the cases of investigations within their scope of practice. Yes.
I didn't know state agencies had the subpoena power.
Ms. Benfield, let me
sorry,
give...
so you said subpoena. They've got the ability in an investigation to obtain relevant information like a law enforcement agency would.
Let me ask Mr. Knox to go ahead and kick it over here, and then we can always come back.
I have more.
Mr. Knox.
Thank you, Mr. Chairman. With respect to the issue of the doctor-client privilege, obviously that can be waived. Would you agree that it can be waived by the patient at any time for any reason, and they can ask to have those or allow those records to be produced as they see fit?
I think this bill is silent on. It doesn't change the existing.
I agree.
State of the law and confidentiality.
I agree. Would you agree that that is the case, though, that a patient has control over their own medical records, and that they can make those available under the current law as they wish, or not, either one?
General so states.
Okay. Secondly, would you agree that the doctor-client privilege is not an absolute privilege or an absolute right? That privilege can be pierced for a variety of reasons, including ones of criminal behavior, where the physician is not permitted to not allow those records to be examined by the criminal authorities where he is accused of having committed a crime. He can't take refuge behind that and avoid culpability simply by invoking the doctor-client privilege. Do you agree with that? All right. With respect to the hearsay rule, have you ever are you aware that the courts have made on more than one occasion in what we call dicta, that is, conversation or statements not exactly applicable to the case that they have under review, but a general comment on issues involving it? That would be that the hearsay rule has really become an exception rather than a rule. There are so many exceptions to the hearsay rule that it's often an issue in criminal proceedings, and that there's probably not very much we can do with respect to the applicability of evidentiary rules when we do any legislation that may affect the criminal code, that we would be able to envision any possible application or invocation of the hearsay rule. Would you agree with that?
Jim so states.
All right. So, that being the case, would you think that that perhaps some of the objections that we've heard may not, in fact, be objections that we might need to address at all, or that are objections that wouldn't come up in any kind of criminal proceeding, regardless of whether it's this or any other criminal Bill.
As a member of this committee sees fit to talk about lots of things. I think it's fair to raise any question. I don't think that the concern about hearsay is relevant to what's provided in 1155.
I think I'd agree with that. Thank you, Mr. Chairman.
Yes, sir. Ms. Bird.
Thank you very much for this bill. Certainly back in 1949 when my parents married, my mother was white and my father was full-blooded Chinese, so I'm certainly glad my grandparents didn't have me aborted. It could be good news or bad news for her. Is this bill not about being unduly influenced to have an abortion?
Yeah, there is a coercion piece in this bill, which is, you may consider the crux of the bill, which, and we do have people that are prepared to testify, Mr. Chairman, in that this coercion does happen here in the state of Georgia, where coercion being that a threat of harm, whether financial or to the safety and security of the person or physical harm, is threatened to the mom or the pregnant woman, that if a, say, biracial baby is brought into this world, then something would happen to them. And I think directly to your point that yes, that is probably a key part of this legislation, is that coercion piece.
Thank you.
Mrs. Cooper.
Okay. To the author of the bill, Representative Loudermilk. I mean, you see now on television ads and in commercials and magazines and things and articles about women who had an abortion and then down the road realized that they wish they hadn't done that and they were sorry that they had done it and begin to speak out against abortion. What is to keep somebody who made this decision based on race and or sex of the child, which would not be noted in the chart anyway or anything like this, and who willingly had the abortion, you know, or you're saying coerced, even had the abortion, but later decides that they did the wrong thing and that they want to seek retribution and they want to blame the physician or the staff member. What's to keep them from doing that? And it becomes certainly he said, she said. I mean, and what's the, you know?
Well, I think the law has already set the bar very high in this, even when it comes to employment law. I mean, it's a very difficult issue to prove whether or not someone was fired because they were Hispanic or because they weren't performing. I mean, that's a very, very high bar. And that same bar applies here, is it's really going to be a burden of proof issue. And, you know, it's not just that she comes back and says that I decided to have this abortion because I didn't want to, quote unquote, bring a black baby into the world. It would have to be that she told that to the doctor, and the doctor knew it when he performed it, because the woman is held harmless in this. So it's not that she had made the decision to do it. It would have to be that she openly said during that time, this is exactly why I'm doing this, and the doctor had knowledge. Of course, that bar is very high, and it will be rather difficult to, it's as it is in certain other areas, to prove that racial aspect.
Okay, Mr. Chairman, may I?
Sure.
Okay. But here again, that's her saying that wouldn't be charted anywhere or wouldn't have been, if she goes ahead and signs the paper and agrees to have the abortion. There are papers you have to sign agreeing to have something like this. So, I mean, so here again it gets to be, and isn't the true purpose, I mean, it's very expensive. Anybody can bring a lawsuit against anybody. And in the medical profession, one of the problems that we have with Georgia having a lack of physicians and OBGYNs are one of our sort of endangered species across the state. There are places where women have to drive 85 miles to deliver a baby because there are no OBGYNs just delivering babies. And wouldn't this law, I mean, and since anybody can bring a lawsuit against anybody, whether it's founded or not, and you have to go through what we're finding when we passed our tort reform, was that because of these frivolous lawsuits, which still have to be answered and would still cost a great deal of money, and are often put in so that there will be settlements, and also is not the true purpose of this bill to set up that kind of scenario so that you can decrease what you think are going to decrease the number of abortions by intimidation and fear and causing fear in the physicians that they're going to be sued.
No, absolutely not. That's not the purpose of this bill at all. And I think in answer to the question on the lawsuits is that there would have to be, beyond just the hearsay evidence of the woman, there would have a burden of proof that would have to be provided in there. But the assumption that this is simply to the assumption that this bill is to limit OBGYNs or run abortion out because a frivolous lawsuit is not the target of this at all. The purpose of this bill is it right or wrong that someone should take the life of an unborn child simply because of the race, the color, or whether that God has chosen that child to be a boy or girl. That's what it boils down to, and that's the purpose of this bill, is population control. We do not believe that the selection should be made of whether a child is born as to what the race of that child is or the sex of that child. That's the purpose of the bill, ma'am.
Mr. Chairman. Sorry, I didn't mean to interrupt you. I thought you paused, and I thought you were through speaking. Given whether that is the purpose of the law or not, the way this is written, it sets up the other scenario. And you can talk about the burden of proof, but in the realistic thing, and I know that you aren't a lawyer and neither is Mr. Setzler, what happens is people bring lawsuits against people, against physicians that are frivolous. But those lawsuits have to be answered. And there's a whole process and a great deal of money spent before they ever get to the point that a judge or somebody decides that they are frivolous. And they are very expensive, and they have and to do that and have a doctor trying to work and go about his business of delivering all the other babies he's delivering and trying to do a good job in GYN and have that hang overhead is a very sobering thing for physicians. And it was one of the reasons that we had so much trouble attracting all kinds of physicians to the state of Georgia before we passed tort reform. And once we passed tort reform and gave them some, some protection, since that time, we have seen a number of physicians coming back into the state in all of the specialties. So I would say to you that any scenario, not saying or going at the basic thing that you're going at about the sex of the child and so forth, but when you set up a scenario that allows for frivolous lawsuits against physicians, you are setting up a problem for them and helping and hurting the rest of the state and attracting physicians, especially OBGYNs, to come to the state. Thank you.
What I'd like to do is we can do one of two things. We can have another round of the witnesses right now or bring up another witness. From a timing perspective, my sense is that we'll have to continue this next week. Given the number of questions that we've had, given the number of witnesses on the list, people come in here and they want to be heard and they will be heard. Is the preference to go ahead and have another round now here, or why don't we do this? Why don't we have another round? I see some lights flashing. If you do want to have another round of the authors right now, we can. We'll do that round and then suspend consideration and go to 11:53. Ms. Abrams, did you want to follow up on that? No, it's fine because we can go ahead and have enough time to do that, Mr. Loudermilk.
Yeah, Mr. Chairman, I would bring up, we have actually flown some people in from out of town. I'm not sure of their availability to come back next week and the expense that they've gone through.
All right, and let's do that then.
We would be able to bring them up.
Absolutely. We can go ahead and do that. We want to be courteous of their, respectful of their time and their efforts. We'll go ahead and have them come up, offer some testimony. If we have time, we'll do a round there, and then we'll suspend and come back next week to allow time for 11:53 today. And I would remark that my secondhand understanding is that we're going to have an extended recess, so we have time on this. Before I forget, I think proponents of the bill from a little while ago have been tasked with providing the empirical data that we requested before. We believe in fact-based decision making. We try to free ourselves of the more rhetorical nature of any debate, and really get down into the facts, into the nitty-gritty as to what's happening, where it's happening, the who, what, where, when, and why. And therefore, members from both sides of the aisle can make an informed decision. We'll do that in addition to some of the structural concerns that may have been that have been brought up. Consider those, and if we do act on a measure, We want it to be the strongest possible work product we can, based on empirical data, based on the facts that have been provided to the committee, so the folks here from both sides of the aisle can make an informed decision. I hope that I hope that's reasonable.
Mr. Chairman, before we have a couple people come up, if I could just summarize for consideration of the committee the things this bill seeks to do very quickly. Thing one is this bill prohibits race and sex-based coercion. It prohibits another person that has power or authority over a pregnant woman from coercing them to perform an abortion based on race or sex. And the prong one of this bill is if a parent or some other person that can exercise power on somebody, this prohibits them from saying you need to abort your child based on race, whether it's a husband forcing a wife to abort a child based on sex, or whether it's parents forcing a young woman to abort their child based on sex or based on race. The coercion piece is perhaps the crux of this bill. This prohibits that coercion. In doing that, it also prohibits solicitation that could exist. We were trying to very systematically lay out the fact that there was a historical program of solicitation in this nation. There's overwhelming statistics that the potential exists today. Whether or not it does, it has absolutely happened in the past, and we believe it prudent to ensure that it would be illegal to do that today. It's anyone's guess whether it's happening here or in other states, but we've seen it happen in the past. We want to make sure that's not legal today. And the third thing it does is it prohibits physicians from being party to those acts. It would prohibit a physician who has knowledge that the coercion's happening, or that has knowledge that the solicitation is happening, that has knowledge that there's someone is seeking an abortion based on race or sex. It prohibits a physician from having knowledge of that and then carrying the act forward and being part of that. So that we've got the check at the physician level. That's what this bill seeks to do, and I think the folks that are going to come speak will speak to the veracity of that.
All right. I don't know who they are, but if you want to go ahead and bring them up. And just to be clear, when we go ahead and do continue this next week, folks who are signed up now and whoever does sign up in the future will be heard. So the process moves slowly, but people will be heard if they want to be heard.
Mr. Chairman, for the privacy of the individual, could we have the TV cameras turned on? Is that possible?
I'm not sure I'm in a position to do that, to be honest with you. This is an open meeting.
Could we make that request?
You understand that it's on a live feed.
It is. It's on a live feed. I'm hesitant, honestly, just to make sure that and given the age of the witness, as I believe I'm observing, from an open meeting standpoint, we err on the side of openness. If that creates a discomfort, I understand, and if that is the case, I would suggest perhaps reconsidering. That's not offered to prevent testimony or persuade or dissuade on that, but we have to err on the side of an open meeting. I hope you understand. Okay. And I'd invite you to introduce yourself.
I'm Susan Swanson. I've worked counseling young women in crisis for 27 years. I have a master's degree in counseling. I've seen much abuse in different forms, but one of the saddest abuses I've seen is the race issue, as far as young women being pressured to have abortions because of race. I brought two witnesses to help let you see into that situation. But I've counseled hundreds and hundreds of young women over those 27 years who had some of that element in their
Hey, Ms. Swanson, I apologize for interrupting, but let me ask you, what organization are you affiliated with?
I work with Augusta Care Pregnancy Center in Augusta, Georgia.
Okay.
Because of that, I very much support this bill because it's protecting women. It's protecting women from coercion by family members, relatives, by husbands, boyfriends that want that person to go through an abortion because they want it, not because she wants it. And I hope that this bill will help change the dynamic in clinics where these girls walk into, that they are listened to when they are saying what they're saying about being pressured. Because we all know what racism has done in our country. I grew up in Tuscaloosa, Alabama, but the whole race issue is very, to me, gone underground within the abortion industry. So I'm going to introduce Alex, and Alex is going to tell you a very personal story, so it's very hard to be here. So I appreciate you letting us speak. But I think she's speaking for many women that have been pressured into abortions in different ways. Okay, Alex.
Mm-hmm. Alex, welcome, and we look forward to your testimony. Just be comfortable, and please don't be nervous. So just relax, and we're regular people.
Okay.
Contrary to what we look like, no, we really are.
I was 14 years old, and I was pressured in and forced by a relative.
Just take your time. Just take your time. And let me give you this.
I was forced into an abortion because of my child being part African American. I either had a decision to get an abortion or be disowned by my family or put out in the streets. When I got to the place, I told them that I didn't want to do it because it was wrong. I felt that it was wrong, that I was killing a child because of the race. And they kept telling me that, oh, you're doing the right thing because of your age and you being so young. And because of me having an abortion in the past, with my current pregnancy, I'm at high risk now. I'm having problems with my current pregnancy.
Can I ask you how old you are now?
I'm 18 years old.
And how old were you then?
14.
Okay, thank you.
I think you need to tell them how it was when you went in the clinic.
When I went in the clinic, the people asked me, how old I was and everything. And, I told them that I didn't want to do it. But they told me, you're doing the right thing because you're young.
She also, did you tell someone there that you were being pressured? Can
Yes.
you say that?
I also talked to one of the people that were helping me get ready for the abortion that my mother was making me do it because of the race of my child. But all they said, they just told me I was doing the right thing.
Alex has also told me that the year later she got very depressed. She had to go into a hospital because of depression from this abortion. So women need to be heard about this. They need to be heard by clinic workers. They need to be heard by the counselors at the clinics. The clinics need to listen to the pressure they're being put under. In 2004, I've counseled many young women who are being pressured by family members to have abortions. This young lady that I counseled in 2004, her father is making her have her second 6-month abortion because of race. That little girl died not long after that. It is undetermined why she died shortly after that. But our concern is that women are not being heard. They're not being listened to when they come in and say, I'm being pressured by this person or that person because of race or other reasons. And that needs to be brought out. So however that can be done would be very helpful.
Let me just make sure I'm clear. Alex, if I'm understanding your testimony correctly, it's that you felt pressured to do what happened by your family. Is that a correct statement?
Yes, sir. I was either in this situation, I had a choice to either get the abortion or get kicked out my house.
When you went to the facility, did you feel was pressure, and this is a matter of your opinion, and you had this experience and no one else here did, so it's a matter of what you recall, it's a matter of what your opinion was at the time. Did you feel pressured at the time from people who were working within the facility, or was it more of a business-like interaction, or is it just you're there and they were there to do what they were going to do? Did you feel pressure from people inside that facility, or not really?
In a way, yeah, because they kept telling me, "Oh, you're doing the right thing," and I knew I wasn't.
Did you feel, as they were telling you you're doing the right thing, did you feel as if you were being pressured to do that, or it was just a statement that they thought you were doing the right thing, but that ultimately you felt comfortable making that decision either way?
I mean, I guess she was just making a statement.
Okay. And, just to be clear, that's, this is an anecdotal, this is one episode, this is one instance, and it should be taken as such, and that's not saying that it doesn't happen additionally. It's not saying that. It's just getting an idea of the experience, because there's no one at this table who's had that experience, and it would be my best guess.
She's not at her house now because she's carrying a biracial baby.
Okay.
I also, with this pregnancy, my mother gave me the choice to either have an abortion again with this one and stay home, or I could keep my baby and get kicked out. So I took the choice to leave.
I see. Well, we appreciate your having the courage to be here today. Regardless of how anyone here at this side of the table feels about the issue, it takes a lot of guts to sit there and to tell a story that's difficult. So I think we'll applaud you having the courage to do that. So, and I hope maybe talking about it helps a little bit.
Now I'd like to introduce Fran that's going to share about the abortion industry. Thank you.
All right, let me recognize Ms. Benfield for a related question, I assume of Ms. Swanson.
You may know the answer, or Jill Travis may know the answer, and I do want to thank you for being here. I know that took a lot, and I wish you all the best with your pregnancy. My question is, and I should know this just for my own edification, but what is the age of consent to an abortion? I know there has to be parental consent below a certain age, and I'm sure in her case her parents did consent since they were pressuring her to have the abortion. But what's the age of consent?
I think they have to have parental consent under 16 if they're 13, 14, 15. I believe that's the law, but maybe I'm not.
Under 16. Okay, thank you.
Is it 18? Notification. They have to have notification.
Under the age of?
I think it's 16.
16.
Yes.
Okay, thank you.
They can get a judicial bypass. I
Yeah.
recently had a 15-year-old that was going for a judicial bypass.
Okay, thank you.
Welcome. If you could introduce yourself, and just if you do represent an organization, if you could let us know. If not, just the relationship of your experience to the subject matter today. Let me ask you, if you could, just in the interest of time, to limit your comments to 5 minutes. There may be questions, there may not be, and then we'll move on from there. If you can move the microphone, or if you can move closer to the microphone. Thank you.
My name is Fran, and I do appreciate your time today. I know it's a very busy session this time around. I am an ex-abortion clinic manager. I have walked out. And the organization I'm representing are women today. And I'm going to represent close to 10,000 women in what I felt as that manager. I am not a licensed medically trained person. I am not an RN. I am not a medical doctor. I do not hold a degree. I was a manager. I can tell you for a fact that women are not given the information. That right to know is not followed. They are not told all of their options. They are not given an ingrained sense to go another direction. You will see many women testify to this once they have healed enough inside to say, I have been through this. This is going to become a crisis for women in the next generation. I can tell you specifically of children coming in, minors, whose parents threaten them within an inch of their lives or with their lives. And as long as that child was complacent and laid there and was okay on that procedure table so the doctor would not physically hurt them, the child would go through with it. That is not a joke. That is not a lie. That is something that happens every day to over 2,000 women that don't want to do this in the United States alone. I've heard statistics today, and those statistics only include the reported physicians who are going to report to Georgia State Department. That doesn't include the small town doctors. The major corporations, they care about get them in, get them out. Most of these patients will not see a physician. They will be counseled over the telephone by who knows. I myself have called a clinic to see. And I was counseled by somebody who was not a nurse, not a licensed counselor. Nobody who had any education in what they were doing. They were doing a paid job following a script. There was no empathy there. I can tell you from experience, from me being the person that was in charge of expanding my company's area, that I looked to put an abortion clinic in a predominantly black neighborhood, minority, down the street from facilities of ill repute, to where there would be a need. We are going to make it accessible. We are going to look at the highways, the interstates, the access roads, and place it to where it would be easily accessible. There are times that I have seen there is a need for it. Women feel trapped in this society. We have to be a mother, we have to be a wife, and we have to have a full-time job. It is hard to make ends meet, especially right now. Black women, yes, they come in the clinic all the time. On a given day, 20 patients, 60 to 75% of my patients were African American. Did I hear sometimes, I'm going to have a white man's baby? Yes, I heard that. Did I hear white women saying, I'm having a black man's baby, that's why I'm doing it? Yes, I heard that. Did I hear the doctor ever say, there are places that you can get help? No, I never heard that. The only time a physician would not do a procedure is if the patient was not physically compliant. I never saw a physician say, it's time to stop. I've heard physicians say racist comments, like another one from welfare. And it's a very sad state. And I believe women aren't being able to speak out. This is an embarrassing subject. This is not something that should be aired on national TV day and night. They're made poster children for a cause or against a cause. Yes, we have the right to choose, but we have the right to make an informed decision with all the information. The people next door can help. The woman outside can help. The one woman who had the abortion didn't help. And now I'm going to help. And I hope they all know that I'm here for almost 10,000 women that I've seen. Know that it's time for things to change. That they do have the right to make an informed decision, that the doctor needs to tell them. Not somebody who is not trained. They need to have counselors of their own ethnicity. Have I seen sex-based decisions made? Yes. Prominent in the Asian community. Look at the history of what's going on in China right now with selection. Vietnam, I have several Vietnamese friends who want male babies. This is not localized to a country most of us will never visit. These are the people that are going to make America tomorrow, and it's affecting today. Today alone, one school will be aborted. No, I'm not asking people to say, yes, this is wrong, or no, this is right. I'm asking people to sit down and take a serious look at the laws that are currently on the books and make people aware that they have to tell the truth, that they cannot sit there and select what they are going to say and what they are not going to say for the possibility of eugenics, which I've heard, to increase the profits for that year, to do what they call is their job for our society. and decreasing the welfare recipients, not all of us are born perfect. I know very few people, and those few people are dead, that are perfect. I know nobody that can make an informed decision with a piece of black and white paper, especially the little African-American 13-year-old girl who was pushed down the stairs because her mother decided, well, if you can't stay still long enough to have an abortion, we're going to get rid of this baby one way or the other. Nobody spoke for her. And everybody was aware of it. And we turned her away. Nothing happened. I don't know what happened to the mother. I was too disgusted to go any further. This is not something that's going to go away. This is not the last time we will be at this table. It is happening. Bigotry, it happens every day. Whether you're at Walmart or you're in an abortion clinic. Sex selection happens every day. We're making decisions that are not ours to make. Women have the right. A 14-year-old doesn't know what Asherman syndrome is. She barely understands sex. A 9-year-old girl doesn't know what scarification of the uterus means. They are not given all the information, and they are being coerced. If your mother tells you you will have an abortion or I will kick you out, that little girl's afraid of the street. She already lives in a bad neighborhood. She already gets to hear gunshots in her neighborhood. She already gets to see the girls raped in her school. What kind of decision is that 9-year-old making? She's not capable of making a real decision. She's not capable of understanding the language of making a real decision.
We appreciate your being here today. Again, I'll say the same thing I did for the previous witness. I know that some experiences are painful, and coming up to this type of environment can be a little intimidating. But thank you for having the courage to do so. Let me say yet again, for those who have been signed up on both sides of the issue, that there will be ample time at a hearing to be scheduled, more than likely next week, for us to continue consideration. What we're going to do right now is suspend consideration of House Bill 1155 and move into House Bill 1153. Well, we're going to go, in the interest of getting to your bill, Representative Levitas, we're going to suspend consideration of 1155 and move to 1153. Again, we'll be able to explore these issues again when we continue the hearing. Thank you very much. Let me ask you, if you are going to exit the room, if you could do so as quietly as possible so we can keep the wheels rolling on the meeting. Thank you. Whatever you're comfortable with is fine. You'll get ample notice in the next meeting, I promise you. All right. House Bill 1153, Representative Levitas.
Thank you, Mr. Chairman. I bring before the committee LC 381054S, which is a substitute to House Bill 1153. I'm going to walk through the bill, but I'm going to, with the indulgence of the chair, notify the committee of my intention to propose rather drastic revision to the bill in conversations with several folks between the time that this bill was, the substitute was drafted and the hearing today. The reason for bringing this bill before the committee is to toughen the penalties and to capture torture conduct that's currently not being captured under Georgia's animal cruelty statute. I'm going to quickly walk through the bill and tell you that the current language defines on page 1 in paragraph 3A3 a definition of humane care. I'm actually not going to go through that because that's one of the things that I intend to remove from the bill. Likewise, on page 4, that talks about improper confinement of an animal in a motor vehicle, I will be proposing to remove that language as well. I'm sorry, paragraph 4 on page 2, at the top of page 2, lines 25 through 29.
You're going to take that out?
I'm proposing to take that out. Of course, that would be up to the committee, but I'm proposing to take both of those paragraphs out. On line 30, I'm going to be making some stricken language plain and removing others. On line 31, the line as it would read would be changed to unjustifiable physical pain or suffering to any animal by an act, an omission, or neglect, striking the word willful. Both subparagraphs 1 and 2 would be stricken, which would match up with the stricken language in paragraphs A3 and A4. Paragraph 3 was inadvertently located in the wrong area. I would be moving paragraph 3 down to the end following line 53, so there would be a 1, 2, and a 3 under the aggravated cruelty to animals. That's where that actually belonged. Continuing with the strikes on line 39 to 41, because we have a different method of punishment, which is that the person would be convicted of a violation, but we've added language in there that would measure the dates within 5 years. That would measure the date within 5 years from each incident. Mirrors very similar language in the driving under the influence code, so that you would be punished for a high and aggravated misdemeanor if you committed a second or subsequent offense within a 5-year period of time. Also, striking on line, striking 1 on line 51. That goes back to the humane language. Striking the subparagraph number 2, not in the language, but literally the number 2, so that it would read, a person commits the offense of aggravated cruelty to animals when, I'm sorry, let me go back. We are bringing down the torturing animals. What we'd be striking is 1, the line 1, and renumbering accordingly, so that you would have intentionally, the first subparagraph would be intentionally causes death or physical harm to the animal by rendering a part of such animal's body useless or by seriously disfiguring such animal. Subparagraph number 2 would now be torturing an animal by infliction of or subjection to severe physical pain motivated by an intent to cause prolonged suffering or pain. And that's the language that's on 35 and 36. And again, the new language on line 57 and 57 to 59, again, is that 5-year period of time, so that an offense would be 1 to 5 years. Subsequent offense within a 5-year period of time would be punished by 1 to 10, and a fine not to exceed Code Section 1710(8). And the rest of the bill is existing language.
Do we have that substitute? I mean, do we have something on paper?
I don't, because this was being done in the halls. I've given it to counsel so that she was able to follow along, and I'm happy to go back over those changes.
No, I mean, that's just a whole new bill. I mean, that, to me, that's a whole different substitute. I mean, it's one thing for us to make cosmetic changes, here and there, usually by consensus and unobjected to amendments. Let me just ask you conceptually, I mean, I'm not comfortable, just as a point of notice, I'm not comfortable in taking a motion on that kind of changes, on those kinds of changes to this kind of substitute without having a fresh product in front of us. That being said, the whole idea of the bill was to provide a strengthening with regard to the willful neglect provision as originally introduced. Isn't that correct?
I think that the original intent of the bill, or the intent of the folks who have been pushing this bill, has been to strengthen the ability to prosecute the torture and the cruel treatment. Humane care was something that they would like to have included in the bill, Not only has there been some concern expressed to me from the wildlife community, the agricultural community, but I don't believe that the bill, quite frankly, would get a signature, even if the definition of humane care were tightened. But some of the concerns that have been raised to me are what, excuse me, what does adequate mean for food and drinkable water? What does adequate ventilation mean? Does that mean you have to have, excuse me, air conditioning within a car, that kind of thing, and that adequate is too vague. And I've talked with the folks who in the Humane Society folks. Their ultimate concern is with the portions of the bill that would survive this editing process. And I'm happy, if it pleases the chair, to bring before the committee a fresh substitute. What I would request is that we go ahead and have a hearing on the bill and then bring it back for a vote at the appropriate time.
I mean, we could do that, but then we're having a hearing on something that we don't really actually have in front of us. I mean, because the issue goes to, and I would share your concern generally from on adequacy and undefined, potentially vague terms. What we don't want to do, and I think the folks in the Humane Society would agree that we don't want to do, is pass a bill that ultimately, because of its vagaries, gets vetoed. By the same token, we really do want to have something, a work product that we can look at. And
well, again, Mr. Chairman, there's not any new language in here, so we could, if it pleases the chair, we could have a hearing on the bill without addressing those issues that we know are going to be removed. But we've got witnesses, I think, from both sides of this issue here, and I just request an opportunity for them to be heard.
And that's fine. We'll go ahead and we'll hear from interested parties. Take those comments into consideration, and then take them into consideration in the context of the substitute for the next meeting.
Thank you, Mr. Chairman.
Probably the way to go. Mr. Hatfield.
Mr. Chairman, just to follow up on that conversation a little bit, I agree with the chair that there's some substantial changes being made, and I find it difficult for us to be able to follow exactly, what we're being asked to consider without having it on paper in front of us. But
I'm sorry.
But I was going to say just a little bit further that, and of course I'm not the author of this bill, but I think that my thoughts about the bill with regard to the humane care provisions, I'm a little bit uncomfortable with some of that sort of language, because it's not my understanding that was the original thrust of the legislation. But I look at some of this stuff like talking about adequate housing, et cetera, for the animals, and I'm hopeful that maybe we'll be able to excise some of those sorts of provisions that are going to be more controversial, so that we can get down to the meat of really what they were intending to get at.
And I think that's where Mr. Levitas was going. The problem is we don't have a work product in front of us. My sense is, and I share your concern, that being said, I think we can get a general idea of the motivation of interested parties on this, digest that, and then keep that in consideration as we take a look at the actual new substitute that we'll look at in the next meeting, presumably. Mr. Ramsey.
Would it be I think there may be some witnesses here that drove a substantial distance.
Sure.
Would it be possible to allow them to testify?
Sure. I mean, just as with the last bill, if people made an effort to be here, I want them to be heard, and we can take into account their testimony as we take a look at the new sub.
And Mr. Chairman, just my understanding from those witnesses, including the witnesses from the Humane Society, is that the total testimony for the three witnesses would be 15 minutes, 5 minutes each.
Sure, that's fine. Let's ask someone from the representative of the Humane Society to please join us and offer their thoughts on the subject matter in general. I'm a little hesitant about talking about specific provisions of the bill because we don't have the final product right now.
Okay. I appreciate the time. Thank you. One thing I just want to clear up, I'm not with the Humane Society. I have worked with a group of prosecutors, and in no time have we ever asked the Humane Society to get involved in this bill. I'm sure they would support it. However, this is a prosecutor's bill, and there were about 7 prosecutors that have worked on this bill.
Could you introduce yourself and let us
Sure.
know who
Sorry.
you are and who
Claudine
you're with?
Wilkins.
That's okay.
And I'm a former prosecutor as well.
And so you're here in a capacity as a private citizen, or as
Yes.
are you affiliated with any particular organization?
I contract with several different ones, but I'm an attorney in private practice.
Okay.
And I also, we just officially made the animal law section to the Georgia Bar, and I'm chairing that.
I see. Okay.
So we get the calls and the cases and the emails about these type of things. Just to be brief, I want to read just one email from one prosecutor so you can get an idea of what we're dealing with. There are several that I have here, but to save time, I'll just say that most of these are the same type of email. The intent behind this bill was to fix 2 flaws in the law. One is the willful neglect, which I hear is an amendment that was put in at the last minute when this bill got passed in 2000. It was a last-minute amendment to add in willful neglect, which means the intentional starvation of an animal. And because of that, prosecutors don't have the tools, if they know for sure, if the totality of the circumstances fit the facts that somebody intentionally starved their animal to death, that they cannot move forward only with a misdemeanor is what they can charge with. We currently have a law that allows for anyone who intentionally harms an animal, who kills it, disfigures it, or makes a body part rendered useless, can be charged as a felon. We do not have any provision that says if you don't do any of those 3, you can still torture an animal as long as you want, wherever you want, but you can't be held as a felon. And there are cases and examples that I can give, and I'll give one in my little 5 minutes. But let me read this from an attorney in Gwinnett County. She's a prosecutor there. Representative Levitas, I've been meaning to email you to say how thrilled I am to see you're sponsoring a bill that is needed. Coincidentally, I'm on my 3rd day of an animal cruelty case, and the jury is to return tomorrow morning to continue deliberations. I can't really get into the facts of this case because it is still pending. However, the 1 count of misdemeanor animal cruelty starvation is the perfect example of why willful neglect language and definition should be removed. Not only is an act, omission, or willful neglect language confusing, but defense attorneys often argue to the jury that the state can't prove animal cruelty starvation because the definition of willful neglect, which is the intentional withholding of food, there is no doubt that the defendant's dog starved under his care, but the state shows that the defendant intentionally or purposely or knowingly withheld that food. We can only pursue on a misdemeanor. Then it says, this case is horrific. This person actually admitted to not wanting to feed their animal. And that's all I can tell you about the facts, but I know for sure that the intent here was to kill the animal. I truly appreciate you sponsoring the bill. And then there's another one here. This is dealing with torture, but basically one case I'll bring to your attention was a man who choked and beat an animal for 11 hours roughly. And he did not kill it, he did not maim it, and he did not render a body part useless. At the time, Animal Control did not know what to do. They charged it as a simple ordinance. They brought the animal back to the abuser, and the animal disappeared. Later, the same gentleman tried to choke his wife, and then he set the neighbor's car on fire to burn it as a retaliation for testifying against him.
Let me interrupt you for 1 second. I apologize. Wouldn't that come under the current felony animal cruelty right now?
It clearly states right now that you have to kill it, maim it, disfigure it, or make a body part rendered useless. And if you don't do any of those, then it doesn't fit in with the felony portion. So I can give you examples where there's cases where people have duct taped a cat, for example, to asphalt for 7 days. They didn't do any of those things, but they tortured the animal for 7 days. Okay. That's just one. There's several. I do have a list that I've given Representative Levitas. So the point is, and I say this on the very week that we had a case where a man killed the family dog in front of the family and is now being looked at for child molestation. So there's a domestic violence component here, especially when you're dealing with the torture of an animal. There is the mistakenly killing and accidental things, but then when somebody intentionally is motivated to harm an animal and torture comes in, there's a domestic violence component there. And there's a total different intent or malice, if you will, when you're dealing with the torture of an animal versus someone who accidentally forgets to do something and causes that animal to die. The other thing, too, is our current law specifically exempts many things. One of those is hunting. One of those is agricultural industry. It goes on further to exempt so many other items, and it's all in the bill at the bottom. That has not been changed, nor will it be addressed or changed in the provisions that we would like to add in. The humane care and the motor vehicle confinement, those are something we're willing to let go of, but the main concern here is to fix those two flaws in the law.
The language, Mr. Levitas, that you referred to earlier, the strikes and the ads, I mean, is that something that's coming as a result of conversations with
correct
interested parties such as yourself?
Right.
Various parties, including Ms. Wilkins and some others.
Is that consensus language?
Yes. We talked about it in the hall. And that's, again, my apologies for having to do this the way we did it. But
and on line 65, you can read yourself the very vast amount of exemptions here. And wildlife and hunting, exhibition, competitive trapping, fishing, wildlife management is all exempt already anyway. And we have 2 animal control officers. One drove quite a long way to be here, and then 2 prosecutors were in trial, and they wanted to be here but could not. So let me just turn it over.
Yes, please. Bring that person up, if you would, the animal control officer. Yes, ma'am. Please come forward. Thank you for making the trip.
Thank you.
Just let us know who you are and where you're from and what you do. And all
My name is Cindy Wyman. I'm the sole animal control officer for the City of Madison. I'm also secretary of the Georgia Animal Control Association.
Could you pull the microphone just a little closer to you? Or
I guess I
come
can.
forward, one of the two. Thank you.
Okay, my name is Cindy Wyman. I'm secretary of the Georgia Animal Control Association. I'm also the sole animal control officer for the City of Madison. I'm also on the Homeland Security Animals and Disaster Planning. This bill is really important to animal control. I can give you numerous cases that were not prosecuted or could not be prosecuted under the current law. In one case, there was a dog that weighed 22 pounds. He should have weighed about 45. When I knocked on the door, the lady came to the door and nicely told me it was her son's dog and it was his responsibility. When I asked how old her son was, she said 6. This could not be prosecuted. The dog could barely stand, but her kidneys hadn't shut down yet, so there was no physical damage. On the torture aspect, I had another case where a person tried to drag his dog to death with a cable. She had an 1.5 inch gash all the way around her neck, and she had 3 puppies. When I took her to the vet, cleaned it up, she was a long-haired dog, there was no disfigurement. These cases can be truly horrific.
And that cannot be tried as a felony right now?
No, cannot. In both cases, I did bring it to the magistrate judge. In both cases, I was told, no. There's not disfigurement. There was not any permanent damage. Starvation is one of the worst. That is a ongoing torture of the animal. And there is, unless the animal dies, as animal control, we're left standing there. I've actually had complaints filed against me to my superiors for cases that were not prosecuted, but the law does not work, does not give me the opportunity to actually prosecute those cases. But my community is demanding, that I do something, and I'm left out there. One more case I'd like to bring to attention. The only reason that there was a felony animal cruelty charge on this case, a man in his 20s threw sulfuric acid on 2 dogs. When it was brought to the magistrate judge, it was reduced to a misdemeanor, which we were going to be lucky to get at that point. But in the meantime, this lovely young man also enticed a 12-year-old for sex. This type of cruelty goes hand in hand with crimes against people. On the starvation cases, it is the DFAC's involvement in these families that starve animals is pretty high. If they're letting an animal starve to death, they probably are not taking really good care of their children either.
We try to be a little careful when it comes to, if someone has committed some sort of conduct and yet there's some other conduct that's not related. We try to be careful in not actually making that connection there. We try to go ahead and concentrate just on the underlying conduct that's the topic of the bill. If there's a propensity, no, please don't. I just, just for familiarity's sake, and this really goes, this is a message from Ms. Wilkins as well, that, while that may be the case in some cases, we have to confine ourselves to, the underlying subject matter. Please don't take that as criticism. It's just by way of information. We appreciate what you do as the manservant for a 13-year-old golden retriever, which is what I am. I really, people like you have hearts as big as this room, and I know you see a lot, and a lot that, and you're strong about it. You have a strength that I probably wouldn't have under this, or self-control that I certainly would not have under the circumstances myself, knowing myself. So thank you for what you do.
It's very difficult.
Yeah, I'm sure those case scenarios do occur. We're hesitant sometimes just to make that connection because it ends up making a more inflammatory argument as opposed to the heart of the matter. I'm sure you understand. But again, thank you for what you do, Mr. Franklin.
If I could ask a question, I thank you for being here and thank you for the great job you do. And I was just curious, in your jurisdiction, what is the most prevalent type of case you're called out on?
You mean as far as just the cruelty cases?
Or any type of case, whether it's cruelty or anything related to you being the sole animal control officer?
Running at large would be the highest volume of calls.
And what type of animal would that be?
Dogs.
Dogs?
Yes, dogs.
Do you get very many chickens running at large, terrorizing children?
By our zoning ordinance, chickens are not allowed in the city of Madison, so no, we don't have that problem.
All right, thank you.
So there. Ms. Wilkins, I know you had another guest that you wanted to have come forward to offer some testimony. Would you, sir, if you wouldn't mind coming forward, introducing yourself, we welcome you. If you could introduce yourself and
Sure,
let us know who you are and where you're from and what you do. We'd sure appreciate it.
Thank you. My name is Miguel Hassan. I'm former director of animal control for Fayette County. I am the voice of animal control in the Companion Advisory Committee for the Commissioner of Agriculture. I am also one of the board members for the Southeastern Animal Control Association. It represents representatives from each state. I represent Georgia on that board. I'd like to tell you a little bit about our current code and some of the issues with it. The intent certainly was with animal control in this code. This is a code that affects animal control and animal control alone in the state of Georgia. That's generally who's out there enforcing these laws. And when they started talking about willful neglect, I envisioned what they saw. But unfortunately, in a court of law, there's a little word in there. We all know what neglect means, but we all don't know what willful means. That has been hampering our efforts. And basically what these in my experience and the experience of my colleagues, what we find is when we get to court, we end up trying to prove what willful is versus what neglect is. In these cases where we have animals that are starved to a point where they're almost into renal failure or at renal failure, and proving why that renal failure exists becomes the issue. We forget really what's at hand, which is that you have somebody who in plain sight, in plain view, in front of children, in front of their neighbors, have rendered or have taken away a vital sustenance to these animals. And these animals have gone through an incredible amount of pain and suffering over a long, long period of time. And when I say I understand the intent, currently in our law it's a felony if you grab an animal and break one of its limbs. You have made that limb useless. You have disfigured that animal. However, our current law doesn't accept or doesn't look at as a felony if you've starved an animal to the point where he's about to go into failure, about to die. And I can attest to this because I've had cases, and I'll bring one to light that actually I'm still involved in, where an individual went on a trip to New York, went on a binge, had a great time, wonderful time in New York, but all the while, there was a dog in a crate that he left inside his apartment with intent that it would care for itself, maybe break out of the crate, maybe get to food and water somewhere. I didn't find food and water anywhere in the house. That animal was within an inch of his life. And now I have to, beyond a reasonable doubt, prove that that was cruelty. And when I do that, that person may go to jail for 3 months to a year, because I cannot prosecute this at a felony level. That's the most I can get, and maybe $1,000 in fines. However, if somebody breaks the leg of an animal purposefully, that animal may see a vet that afternoon, may recover from that 3 months. This animal did not recover from this behavior. That would be prosecuted as a felony with up to 5 years in prison. So that's where the current flaw is in the system. And like I said, I think the intent was there. The language, unfortunately, has made it impossible to prosecute.
I'm sorry.
I want to thank you all for listening to us. I know this is difficult testimony to accept, but bear in mind that we're the ones in this position. It's difficult testimony to accept, but it's even more difficult to see it out on the field, and that's why we're here, both Cindy and I, taking time out of our days to come to talk to you about this. But thank you for listening to us.
Well, thank you for making the appearance and for giving us your perspective. This is what we need to hear in order to make an informed decision. We need to get the perspective of people who are, boots on the ground, as the saying goes. Mr. Hatfield.
Thank you, Mr. Chairman. I just had a comment in light of the testimony from was it Wyman? Wyman. Okay. That apparently there is some feeling or some finding that persons who abuse or torture animals are also typically involved in some domestic violence or maybe crimes against other persons. And I understand that, and I think that there's probably a certain depravity of mind that exists for that a person who would torture an animal could easily slip over into doing things to other humans. But having said that, I think that the committee should I think in considering this legislation, we don't need to be considering what a person might do or have a propensity to do in a situation against a person. I mean, we already have laws that deal with those situations, but this legislation, we need to decide what exactly the boundaries are in terms of conduct towards animals, and it needs to be justified on its own bottom, so to speak, in my opinion. And I do think there are some really sick people out there who do some terrible things to animals, and there should be some legal protections there. And so I'm very interested in working with y'all on this bill, but I hope, with Mr. Chairman, that we don't take our eye off the target here in terms of saying, well, these people are also people who have propensity to do something to humans, and so that somehow justifies what we're doing here. We need to make sure that this is the right thing to do, with regard to the subject matter itself.
No, the gentleman's point is well taken. I think I made the point in some way earlier, and of course Ms. Wyman, in her capacity, was simply speaking from her experience, and don't have any issue with that. We scold Ms. Wilkins just a little bit for making the propensity argument, but not too much. But I think we all share that point, that we're, again, words on paper, the underlying subject, and not getting into what are important but ultimately really not relevant to the underlying piece of legislation. So I appreciate the comment. I think we all know where we're at on that. Thank you. Mr. Levitas.
I'm going to stick up for my witness a little bit here. I agree that the main thrust of the bill has to be that, but quite frankly, I think a relevant consideration is what are the propensities for these folks, and if we can catch somebody and address that conduct before it leads to other conduct, I think that's a relevant consideration. We do that with other laws.
And I don't disagree. I mean, that's a bonus, as I would call it, but not an underlying motivation. I think we're on the same page, and if we get to that by virtue of doing this from an anecdotal standpoint, of course you can't measure that because it's a speculative thing for the future, but I don't disagree with that. All right. Mr. Rob Miller. Okay.
Hey, guys. Thanks for hearing me. My name is Rob Miller. I represent myself. I actually spoke to a bill Monday on with regards to animal cruelty. In that testimony, I opened up by saying that I was going on Wednesday, that was yesterday, to pick up a foster. We picked that dog up yesterday, and he's at home acclimating with us, and we look forward to helping him get placed very soon. I do appreciate the proposed changes to this bill by the good representative. My question is really why this is in Title 16 instead, and why we're focused on Title 16 with regard to animals, and not on Title 4, which is the section that applies to animals. And there are definitions in 411.2 that say adequate food and water and what is humane care, and in the offenses in 411.16 it says that any that every single offense is calculated as a separate offense. So if someone is not feeding and not watering their dog, that looks to me like two separate offenses according to Title 4. Whereas Title 16, it appears that maybe we're prosecuting folks under the wrong code section. That's really my only offering, and I would ask that the advocates for the bill and the authors and sponsors of this bill to consider those code sections and maybe some consistency between the two different sections.
Thank you very much.
Thank you.
I don't have anybody else signed up to speak on 1153. What we'll do going forward is we'll get a copy of the substitute. If we could have an electronic version sent out as soon as it's available, just so members can take a look at it prior to the next meeting. The intent will be at the next meeting to tee that up first, take action on it, and then move on, given the fact that we've gone through the hearing today.
And I appreciate your taking the time to have the hearing, and again, I apologize for the last-minute nature of the amendments.
Not at all, and happy to do it, and I appreciate the travel that folks have made to be here to offer their perspective. It's invaluable, and thank you again for what you do. With that in mind, anything further from members of the committee? We will not meet tomorrow. We will meet. There'll be a schedule that'll be sent out probably tomorrow for meetings next week, along with agendas. Some of that is contingent on subcommittee action. Some of it is not. But we'll try to get, number one, agendas out as soon as possible, along with potential substitutes, so that members can go ahead and take a look at those, prior to the next meeting. And with that, we'll adjourn. Thank you.